Hello.
Hello, sir. Good evening, sir.
Good evening. Are we
evening,
set?
sir.
This is the cyber class.
Yes, sir.
Okay. We have to round up our something today, isn't it? We have to round up our discussions today. The two groups are to make their presentation. Then I will briefly discuss the enforcement of foreign judgment. I might send some material to your group to read on it. So can we have group A now? Now, before we go on, the class governor had discussed with me about some people who somehow did not indicate their names so as to be included in any of the groups because maybe technology failed them or something. I think about 5 people requested of me that I put them in group 1. But when I discussed with the governor, I see that was not going to make sense because the groups had already concluded their task. So just take note, if you are one of the 5 people, firstly, that I'm not going to put you in any group. Secondly, it is most likely that I ask that people should present in summary form what their group wrote. That is, if we listen to the group presentation and they are good enough. So what you would do in the exam is to indicate that you have adopted the group presentation. Okay? You have adopted, you will say you have adopted group A presentation or you have adopted group B presentation. If a question comes saying that you should present the seminar of the presentation of your group in say 500 to 1,000 words, something like that. Okay? Introduce yourself by saying that you are one of the 5 people, but you have adopted this group's presentation as your own. Okay? However, for the purpose of the exam, you are going to be examining over 100. We are going to examine you over 100 and adjust it to 5 slots. For example, if you score, at the end of the day, that's what I would do, because it will not be fair for me to give you the mark that those who actually did the work scored. But if you adopt the group presentation, you go over it and you are able to present the summary of it in an exam, you have done something and you deserve a mark. The only thing is that you don't have a CE, so your exam will be over 100. Okay?
Thank you so much, sir. Yes, sir. Thank you so much, sir. However, sir, we personally, I and 3 other people joined group 1. We worked with them. I'm even supposed to present today on behalf of group 1 before Temi now gave the directive from you that our scores will be over 100. And based on that, the group 1 coordinator now asked that we remove our name from their list. But we worked with them. We reviewed the documents we do present today, sir.
class governor. You didn't tell me that. Is it correct?
Good evening, sir.
Yeah,
Sir,
good evening.
I don't know, sir. I wasn't told. They didn't tell me all of this. Can you hear me, sir?
You are not in.
Can you hear me, sir?
Hello?
Good evening, sir. Can you hear me, sir? Good evening, sir.
Yes. Yeah, good evening.
Yes, sir. I
Group
said
one
I
members.
didn't.
Group one members should indicate whether what she had told me is true or not. If it
Good
is
evening,
true,
sir.
yeah, good evening.
Yeah, this is from Group 1. So it's accurate. They joined us to the beginning of the week when they saw how things were going and they started working with us.
So how many of them? There are 5 people. Is it all the
3
5
people joined
or
us. No, just 3. 3 of them joined us.
so can you amend your list to include the 3 after presentation?
We shall, sir. Thank you, sir.
So which means we are talking about only 2 remaining people now who did not have any group.
So I think there are 3, sir, because one other person reached out. So there were
Okay, so
6 in
there
total.
were 6. These
Yeah.
are probably people who have not been attending classes. If you find out, because I was listening to the class governor giving directive that day. But anyway, so include the name of the 3 people in your list after presentation so that I know those who are with Group A. Can you present now? Can the Group A people present now? You can go back to your original plan before you remove their name. Let whoever is going to present.
Yes, so Miracle will help us and present.
Okay.
Okay, thank you. Please, someone from Group A, please just share the slide. So we wrote on the topic, a working. Someone from Group
Good
A
evening,
share the
sir.
slide.
Sir, we are unable to share the slides. The only the host is allowed to share. If you could allow me share the slides, sir.
Let me see whether I can sort that out. To do that, I will need to have the host key, which is a 6 to 10 digits number, which I don't have. You know that they created this link for us.
Okay, sir.
Do you have a WhatsApp group?
Yes, we do, sir.
Am I included?
No,
think
sir,
the
but I can write
Include
me
me
join
and
add you, sir.
send this your whatever to the WhatsApp group. We can follow, we can okay, because me, I'm working with both my laptop and my something. I can be looking at the something on the. Can you present it well without sharing slides?
Yes, I can present it, and the slides have been shared to the WhatsApp group earlier today.
Yeah, okay, it's all right. You can later send it to me so that I can look at what is it that we are looking at. So go on, please.
Okay, sir. Thank you, sir. So the topic is a working knowledge of private international law as a key to understanding litigation and arbitration of online transaction disputes. So our work explores what we basically did in the work. We explored how a working knowledge of private international law is essential to effectively litigate or arbitrate online transaction disputes. So our work investigates how courts and arbitral tribunals resolve cross-border conflicts, drawing on legal principles, statutory instruments, and case laws from both Nigeria and international perspective. And our work highlights how jurisdiction navigates forum selection, choice of law clauses, and enforcement challenge. So, we keep hearing private international law. So what is private international law? Private international law simply means, or it's known as conflicts of laws. It can be called conflict of laws. So the usage of these terms, it may differ based on the jurisdiction. In the US, conflict of law is commonly used, while in Europe and other Commonwealth jurisdictions, private international law is most likely preferred. So conflict of laws arise when a dispute involves more than one legal system, which will lead or necessitates procedural rules to determine which jurisdiction's law will apply. So this conflict of law usually arises in three critical issues, and they include the jurisdiction, choice of law, and recognition and enforcement of foreign judgments or arbitral awards. So basically, what we are saying is that private international law is a branch of law that governs legal disputes involving foreign elements in relation to nationality or domicile of the parties, place of contract, if it's a contractual issues, performance, or where a wrongful act occurred in tort cases. So a working knowledge of this private international law will help us resolve issues of jurisdiction. So it will help you resolve which court has jurisdiction over a case, which law should apply, and will a foreign judgment or arbitral award be recognized or enforced. So the scope of private international law it's actually different from public international law. Private international law deals with conflicts that arises between private individuals or corporations when it includes one or more legal systems, while public deals with relationships between sovereign states and international organizations. So the core doctrine of this private international law are jurisdiction, okay, I've stated it earlier, jurisdiction, which is the foundational, it's a foundational issue, and it determines whether a court can hear a case and has foreign elements. Whether a court can hear a case that has foreign elements. So these issues, they usually arise in online transactions, as we see today, where the parties involved, they've never met themselves and they may reside in different countries. So in this type of situation, the court considers the domicile and habitual residence of the parties, place where the contract was formed or executed. Then if it's a tort case, where the torts occurred. Then another core doctrine of private international law is choice of law. So once jurisdiction is established, the court will determine which law will govern the substance of the dispute. So for contracts, this may be the law expressly chosen by the parties involved. We also look at the country with the most significant connection to the transactions, and in thought, it could also be the place where the harm occurred. It's also called lex loci delicti. And another core doctrine is the recognition and enforcement of judgments and arbitral award. So if a judgment or arbitral award is issued in one jurisdiction, a party may wish to enforce it in another jurisdiction. But private international law, it provides conditions under which foreign judgments and arbitral awards are recognized. And they include, number one, compliance with due process. You have to plead the foreign judgment and you have to prove it. Then absence of fraud or public policy violations. So if the foreign judgment is brought forward and it does not violate any public policy, and there is no, when you look at it, there's no trace of fraud or undue influence or anything that would violate the judgment, it can also be enforced. Then also mutual reciprocity for judgments. For example, we have for judgments, mutual reciprocity, and for arbitral awards, we have the New York Convention of 1958. Also, private international law now also addresses issues like cross-border insolvency, family law with international dimensions, and online dispute resolution, ODR. So in Nigeria, private international law is derived from case laws, which is the judicial precedents and statutory provisions, such as the Sheriff and Civil Processes Act and Arbitration and Mediation Act of 2023. We also have international treaties such as the New York Convention and Hague Convention, which are selectively applied. And in cases, we have some Nigerian cases that has been held in terms of issues relating to private international law. For example, the TOFA of New York against Edo-Olo Trading as John Edo-Olo and Sons, where the Supreme Court held that foreign arbitral awards may be enforced in Nigeria by suing on the award directly. And in doing this, you sue on the proof of a valid arbitration agreement. You must show a proper arbitration process and validity of the award itself. Also, in Marine and General Assurance against Overseas Union and 7 others, a judgment from Queen's Bench Division, England, was successfully registered and enforced in Nigeria. And the foreign, under the Foreign Judgments and Reciprocal Enforcement Act. Then a host of other cases we have cited in our work in the seminar paper that we shared on the class group. Also in choice of law, we also have other cases, the Sona Nigeria Limited and another against Pattern Reed, Norwind and another, where the Nigerian court held that courts should respect a bona fide and reasonable choice of foreign law made by parties. It promotes international commercial certainty. Now, what is the relevance of private international law to online transactions? So with e-commerce that involves parties in different countries, for example, platforms like Amazon, Alibaba, Jumia, and the rest of them, based on these platforms, issues are bound to happen. So from the transactions, disputes that may arise are usually linked to non-performance or breach of contracts, misrepresentation or fraud, payment or refund failures, intellectual property infringements, data privacy violations. So without adequate knowledge of private international law, both the courts, lawyers, and arbitrators would struggle to effectively adjudicate these cases. So let's go to the internet transactions and emerging legal challenges. So the digital age has transformed how individual businesses and governments engage in commerce. Transactions that once required physical interactions are now conducted seamlessly online, often across multiple jurisdictions. However, this transformation has given rise to new legal complex issues, particularly in issues in determining rights, duties, and remedies of parties in absence of clear territorial nexus. So the nature and types of these internet transactions include from business to business, such as cross-border software licensing issues, business to consumer, for example, services provided by Amazon, Jumia, and Alibaba, consumer to consumer, so sales and the social media usage we do every day, the freelance and remote services, such as on Upwork and Fiverr. So what are the key features of online transaction affecting legal analysis or in our legal environment? The first one is borderlessness. So transactions, due to the unidentifiable geographical origin or endpoints, people are in different countries conducting e-commerce activities. You will not know who is who. Also, the issues of anonymity rises. For example, parties are unaware of the legal status or even the true identity of counterparts. For example, I'm presently facing issues as regards to this anonymity, and I'm sure other people must have experienced same. Also, issues as regarding electronic consent agreements that are concluded by clicking of buttons, such as click wrap or browse wrap, or even issues as relating to proving electronic signatures online. We also have issues as relating to digital evidence. Now, with the rise of AI and the internet, people do all sorts of things. People can maneuver all sorts of things. They can tamper with documents even without finding out. So now we go to the legal challenges in online transactions dispute. So firstly, the major legal challenge we have is the issue of jurisdiction. And this is one of the core issues in online transactions generally. The question that usually arises here will be whether a Nigerian court has jurisdiction over a US-based e-commerce site that transacts with a Nigerian consumer, or if a server is located in one country and the buyer is located in another country. For example, we are all familiar with the case of Lycra against Yahoo, where the French court ordered Yahoo to block French users from accessing the content hosted on its sites. And it was hosted in the US-based sites. So Yahoo argued that the ruling infringed on the US free speech rights, leading to a landmark conflicts over jurisdiction and public policy in online content regulation. We are aware of this case. We did it last semester. So in this case, you see the issue of jurisdiction, the conflict of law, which law will apply. Is it the French law, or the law in US? The issue of public policy of US stating that it infringes their public policy and their rights in the US. So the courts have come up with evolving judicial tests for online context. For example, the targeting test, the effect test, and the Zippo sliding scale test. For the target test, it means that the court checks whether the online conduct was intentionally directed to a user in a specific jurisdiction, and if the website clearly markets its services to users in that country or jurisdiction. And the effect test simply tells us, it simply states that the court asserts jurisdiction where the effects of the online conduct, such as reputational damage or economic harm, is felt within the forum. And in the Zippo sliding test, this Zippo sliding test, it was formulated in the Zippo Manufacturing Co. against Zippo.com case, which distinguishes websites based on the passive websites, which merely provides information, and it does not confer jurisdiction. Now, the Nigerian approach to jurisdiction. Nigerian courts still predominantly rely on traditional jurisdictional principles, although global trends are beginning to influence domestic judicial reasoning. In the landmark case of the Spilada Maritime Corp against Consulex, the UK House of Lords established the doctrine of forum non-convenience, permitting the court to decline jurisdiction where another forum is clearly more appropriate. Nigerian courts have increasingly invoked this doctrine in cases involving foreign elements, although not specifically in the online context, but Nigerian courts have also adopted this case. So this case and this adoption reflects the gradual openness to adopt more flexible jurisdictional reasoning as internet disputes becomes more common in Nigeria. Also, in Nigeria, in determining which legal system governs an online internet dispute, where the parties are located are also very crucial. So where the parties are located in different countries and operate under different legal systems, the modern e-commerce platforms presently, they usually include terms of services. For example, if not just e-commerce, most of the online transactions we do these days, you would see terms of services. When you click, you have accepted. So they include these terms that specify the applicable laws and dispute forums. Most of those terms of services, they would always state maybe a dispute resolution mechanism or the laws that will apply in such when disputes arise. So these terms and the courts that the parties have agreed to would usually apply, except it's they won't apply whenever it's contrary to public policy or it's incorporated deceptively without sufficient notice to the user. So under the Nigerian law, the principle of party autonomy is widely accepted. Courts generally uphold choice of law clauses in both offline and online contracts, as long as they do not contravene overriding public policy. However, Nigerian courts may still scrutinize such clauses where consumers are disadvantaged, particularly when dealing with foreign digital service providers. In SPDC against Crystal Integrated Natural Resources, the Nigerian judiciary reinforced the importance of respecting the parties governing law choice, a principle that would apply equally to both online and offline contracts. So the attitude of both the court to arbitral awards. Normally, courts and arbitral institutions are becoming more receptive to digital innovations. So the COVID-19 pandemic accelerated the adoption of electronic service, virtual hearings, and digital evidence. It has further legitimized ODR practices. However, concerns persist regarding the due process, which guarantees access to technology and enforceability of ODR outcomes, particularly in countries like Nigeria, where infrastructure may be lacking. For example, in this online dispute resolution, you see sometimes when you even in litigation, when you go to court sometimes for virtual hearings, you keep adjourning, and this is usually because of one technical issue or the other. So Our work also viewed comparative analysis of conflict of law approaches in selected jurisdictions. We looked at the EU approach.
You don't need to go into that.
Okay, sir. Okay, sir.
Just conclude now.
Okay, sir. Okay, sir. Okay, so we've stated that the Nigerian's approach to private international law is grounded in English common law practices and supplemented by our statutory provisions and judicial decisions. And the applicable law in Nigeria is that Nigeria usually upholds party autonomy, particularly in commercial agreements. However, this autonomy is not absolute. Courts may override a choice of foreign law if it's contrary to Nigerian public policy, or where certain statutes in Nigeria have provisions for mandatory application. So in conclusion, the rapid advancement of digital technologies and the growth of global e-commerce have significantly outpaced the traditional legal frameworks, especially in dispute resolution. So understanding and applying private international law principles is now indispensable for navigating the legal complex issues of cross-border online transactions, which often involve jurisdictional disputes, conflict of law, and enforcement challenges. For Nigeria, the lack of a codified and comprehensive private international law regime, coupled with reactive judicial approaches, creates uncertainty and limits the country's capacity to manage digital disputes effectively. So lessons from other jurisdictions such as EU and US shows the value of proactive legal reform in creating predictability and protecting consumers, and also fostering economic competitiveness. So we recommend that Nigeria should have a codified private international law provisions, that we should ratify and domesticate key international treaties, institutionalize online disputes resolution in Nigeria, strengthen our consumer protection in e-commerce, and enhance judicial and professional capacity. And also, and finally, we should promote public awareness and legal literacy. Thank you. This is it for Group 1.
Very well. Any comment or discussion? Any comment? Now, go and be practicing this question. Go and be practicing this question. You might be lucky, we might repeat it in the exam. Okay? So take down your biro and your paper and write down this question. Can I go?
Yes, sir.
Yeah. What the World Wide Web? What the World Wide Web has done is to link legal districts. Is to link otherwise separate legal districts. Otherwise separate legal districts. Together as if the world is one global village. As if the world is one global village. However, this has meant These are meant that understanding the rules, understanding the rules of private international law understanding the rules of private international law has become necessary. Okay? So, read what they have said and try and see how you can use it to answer that question. How can you use what they have presented to answer that question? Basically, what we are saying is that transactions or legal relationship that are cross-border in nature are easy to identify. We are easy to identify in the days when legal districts were separate, both in fact and in law. They were easy to identify when legal districts were separate, both in fact and in law. And parties who do cross-border transactions will know that that is what they are doing. Okay? But with the advent of e-commerce, e-transactions, World Wide Web that link everyone together, and with a touch of the button, you could be doing things with someone, you could be in Lagos and be doing things with someone in anywhere in the world. Okay? So if you don't have knowledge, you don't have a working knowledge of this thing I'm doing, suppose there is any dispute, how do I get it resolved? Where do I go? Which law will apply to it? And how can issues of enforcement of whatever judgment are obtained, how can they be resolved? If you don't know all of this and you are entering into online transactions, then you will learn too late, because there is no worldwide court. You have a worldwide web that link you together, but there is no worldwide court that will resolve your dispute. You will eventually have to become territorial at the point that you are seeking relief. And so in those days, when the internet was not an issue, even the mere fact that you might have to travel from one territory to another will constantly remind you that you are crossing borders. And so that would make you know that you have to agree that, look, I'm from Nigeria, you are from UK, we are doing transaction in Switzerland. What is the law that will govern this transaction? Should there be any dispute, where are we going to resolve it? If it is going to be by arbitration, where is the arbitral tribunal going to be? Where is going to be the seat of the arbitral tribunal? If it is going to be litigation, in which legal district courts are we going to approach? All of these you would be forced to resolve in those days when transactions do not have to be through the World Wide Web. Because you yourself will be conscious that you are doing something that is extraordinary. You are crossing borders. But now that all you need to do is press the button on your computer and read WhatsApp or whatever web link you have, the tendency is for you to forget that you are also crossing borders by that press of the button. And that the very same issues that would have arisen if you have had to travel to that place or the other person had had to travel to your country would also arise when any dispute ensues from your relationship. So, the Yoruba people, they say that you don't want to get infected, okay? You don't want to get infected by sexually transmitted disease. You take all the pain to ensure that you do not have a deal with somebody else's wife, but you are not sure. The only problem you have is you are not sure whether your wife will be engaged in such with somebody else's husband. That was in the days when there was no internet, whatever. Today, you can't avoid it. No degree of care can prevent you from transacting online. And so, if in those days you can show disinterest in private international law, today your value as a legal expert will be greatly reduced if you do not know the rules of private international law. Even your value as a businessman, as a person who does transactions all the time, will be greatly reduced if you are not guided by the rules that determine proper venue of litigation, arbitration, applicable law, and enforcement of foreign judgment. So that's all that we are trying to say, that if for people who do not transact through the internet, private international law was probably an option. It's no longer an option today because everybody transacts through the internet. And what the internet has simply done is to provide us one single forum, as if the world was a global village. But that thing that internet has done factually, it has not been able to do legally. Okay? You do not have one territory for purpose of litigation, you still continue to have different legal districts. And it is those legal districts that would superintend the resolution of dispute, whether as seat of arbitration or as venue of litigation. Okay? It is their law that will govern the dispute, whether as the expressly chosen law by the parties or impliedly chosen law by the parties. And so familiarizing yourself with the rules of choice of law would be absolutely necessary today. You won't leave it only for having international law experts. You have to have a working idea of it. Otherwise, you'll be at loss if you were to advise people who will consult you as an expert in this area on what they should do. So that's all that the seminar paper is all about. And in fact, it's all about what your course, the LLM, the dispute resolution in cyberspace law is all about. Okay? So shall we go to group 2 now?
Yes, sir. Good evening, sir.
Good evening.
Sir, please permit me a few seconds to connect with my laptop and be able to share my screen.
No, we had a problem with sharing screen. They say we have to make you host. And when I
Okay, sir.
wanted to do it for group 1, I was required to get a 6 to 10 digit. I don't think we have all that time. If we had
All right,
known
sir.
that we wanted to do this, I would have gotten it from the faculty. So let's go. Just send it into your WhatsApp group. Send it to me.
Okay, sir.
So that I can go over it for purpose of awarding you mark over 20. Now, before you go on, we have treated the issue of 3 people out of 6. The remaining 3 people, their situation will remain what I said, which is that they are not going to be part of any of the assessment of the 2 groups, but we are going to assess them over 100 for the exam. But they are going to indicate, they are going to indicate in their exam question, if any question was asked, that they should present a summary of what their group presented. They are going to introduce themselves by saying they were not members of any of the 2 groups, but they are adopting this particular group. Okay? If you go ahead to discuss group 2 or group 1, and I find the list of group 1 members and your name is not there, you score 0 for that question. It's very, very important. Very, very important. So go ahead now, group 2.
All right. Thank you very much.
Good evening, sir.
Yes,
Temita,
good evening.
Okay,
Are you still asking
Jennifer,
questions?
please go ahead after the call. No, sir, no. I want to address something, sir, but after the presentation, sir.
Okay, okay.
all right. Thank you so much, sir. Good evening, sir. Good evening, class. So I'll be presenting on behalf of Group 2. We'll be looking at the topic. We'll be discussing the case of Does and Facebook, and I'll be representing my group. So In this digital age, we all agree that this digital age is characterized by growth of a lot of online transactions, and consumers and the general public go into a lot of digital agreements and contracts. And this has become inevitable in the society in this present time. And the instant case of Duets and Facebook critically emphasized the difference between traditional business transaction and online transaction, highlighting how traditional legal doctrines have incorporated into this present day and digital environment some standard form agreements. Some digital contracts like click wrap agreements and browse wrap agreements have become the norm in this present time, and have continually um, been unilaterally drafted and imposed on consumers and the general public by providers and owners of different platforms without option of negotiation by the consumers. And with this growth in technology and the existence of these digital agreements, it clauses the standard form agreements and existence of these clauses have moved ahead to bind consumers, limiting their liability to negotiate these clauses and agreements, and making um forum selection mandatory on them, and they do not have the option of negotiating for arbitration or even selecting jurisdiction to resolve disputes if such occurs. So the challenge, one of the challenge that have been identified in this present is the challenge of jurisdiction, the ability of consumers to select the jurisdiction that governs their legal dispute, bearing in mind that they've been able to go into this contract sometimes without even knowing that they have entered into such agreements by engaging in the existing platform or accessing the service of the service providers and existing platform. And the issue of jurisdiction has given rise to a lot of questions. Some of the questions like which jurisdiction should apply if disputes occurs, and which country's law should apply if that dispute goes ahead. So the court has looked and tried to resolve these questions that have evolved due to the growth of technology. And so the court in the case of Zippo Manufacturing Company and Zippo.com Incorporated introduced what is regarded as the sliding scale test to determine when a court should have jurisdiction. And one of the points raised by the sliding scale test is the issue of interactiveness of such a consumer or such user, the interactiveness of the website. So the court said in the case of Zippo Manufacturing Company that the interactiveness of the website should determine where online service providers can be legally accountable, and the interactiveness should be measurable, and it should be in real time. The impact of the interactiveness should be able to determine which jurisdiction should override where a dispute ensues. And this is still being debated in some jurisdiction. So not all jurisdiction have been able to accept this particular sliding test ratio to determine which jurisdiction should override when there are disputes regarding online transaction. So this was also what the court looked into in the case of Google Incorporated versus Egos Tech Solution Incorporated, where the court ordered that a certain search result should be removed from the Canadian jurisdiction as it is termed to affect the people of that jurisdiction, even though that the service providers were not physically located in the Canadian jurisdiction. So another challenge that have come up is the issue of consumer protection. How to balance the how to balance the protection of the consumers' rights and the the enforcement of the existing standard form agreements. So the existence of less protections, unlike there's existence of less protection, unlike traditional transactions where consumers can easily challenge and negotiate this existing contract. Say, for example, if two parties enter into a contract and it is written down and it's for the access of a physical service, it is easier for both parties to negotiate and also come to a compromise. But in this present time where parties have access to access service online, and people can easily go into close start and close a transaction in the digital space, there is limitation of that protecting the consumers' rights, because most times the contractual terms are not negotiable. And just like we have the click wrap agreement and the browse wrap agreement that only requires one who accesses these services online to just click. So by just clicking, the consumers already enter the agreement without knowing. And most times their rights are not protected because it doesn't give them the opportunity to negotiate. So and another challenge that we identified in the course of looking at the instant case is the issue of the role of data in online transaction. So presently, because people can easily access service online, and it has also become inevitable, the data of people accessing services online are at bear to the public or the providers of such service. And the algorithm most times are very, very suggestive, where sometimes you can, by you just watching a particular ad on the digital space, you see similar ads being displayed for your consumption, so exposing your data based on user behavior. So however, there are several legal frameworks existing in different jurisdictions to also help in the protection of the consumers rights and data, like the GDPR, the NDPA, like the GDPR and the NDPA for that applies to the Nigerian jurisdiction. So when we look at the significance of 2 minutes, please. When we look at the significance of the research in the case of Doers Against Facebook, the significance of the research made so far is to strike a balance between consumers' rights and the old transactions, old traditional way of transacting between parties. So we for the present time, you will often see a lot of contracts that the old standard form of contracting no longer exists in this digital time, where there is existence of a click wrap and browse wrap agreements that do not allow consumers to negotiate, and by just clicking they have accepted and they have already contracted with the other party. So the significance of the research is to see how to create a balance between these consumer rights and the old traditional way of transacting. So another significance is that the research offers opportunity to explore how traditional legal doctrines like contract and forum non-convenience can be challenged in court, giving room for procedures and what is applicable, has also been provided by the sliding test, as seen in the case that I mentioned earlier. So when we look at the case in question, the instant case, the case of Does against Facebook, the case is actually about the feature that was introduced by Facebook in 2011, where Facebook introduced a sponsored story feature where whereby the algorithm of a user's interactiveness on Facebook, the Facebook can be able to run ads and a sponsored story ads or on your behalf without outright consent. So it involved a lady known as Deborah Does, who lived in Canada. So where her profile was used, and her profile was used as a suggestive sponsored story suggested to her friends without her consent. Say, for example, where if someone makes a post on Facebook saying that I like to travel, Facebook automatically adopts such post made by an individual, attaching the individual's profile picture and profile background, and shares it as a sponsored story to friends or people that are on your mutual list on Facebook. And this was the what happened to Deborah Does, and she challenged the action, saying that it violates her private rights as provided by the British Columbian Privacy Act, and which makes it actually unlawful for one to use either name or image for any sort of advertising purpose without outright permission, and allows the individual to actually sue for unauthorized use of their name or likeness for promotional purposes. So the lady in question now started a class action, not just for herself, but on behalf of other users of Facebook who have had such challenge or such breach of their privacy rights. So Facebook raised a defense, pointing out that the terms of use which is seen on Facebook actually delineated any legal dispute to be instituted in Santa Clara County of California. However, the lady in question, because she is not in that jurisdiction, started the action in a different jurisdiction, started the action in the British Columbia. So she argued that the terms of use should not apply in this question, stating that it was written in a standard form contract, giving her no room for any sort of negotiation, and also that this involves public interest and her privacy rights is also involved. He also raised the point of the fact that the case that taking the case to a different jurisdiction will rather be unfair and more expensive for her to cover. So at the point where the case went to instituted in the British Columbia court, the court declined jurisdiction, making reference to the terms of use as 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 raised in defense by Facebook. However, when she finally took the case to the Supreme Court of Canada, Canada ruled in favor of her argument, holding that the clause was unenforceable because of the imbalance between the owners of the platform and the users, and also pointing out that the dispute involved relates to public interest and privacy rights, and by the provision of section 3, not section 3, by the provision of the Privacy Act of Canada, that it's a very important matter, and the Canadian courts will have will allow jurisdiction to the British Columbian courts. So the majority of opinion of the judges recognize that standard form contracts are actually do not allow consumers to negotiate the contract, and it's automatically imposed by those digital platforms, often leaving little or no choice to the consumer. So it's more or less like a take it or leave it kind of contract. So at the end of the day, the Canadian court stated that the British Columbian court should have jurisdiction over the matter, to be able to actually protect the privacy rights of the Deborah Doers in question, and also to create a balance between privacy rights and public policy.
Very well.
So
Very well. Mm-hmm. Do you want any more things to say?
yes, sir. So we're able to pick some points around the legal test that was applied by the Supreme Court to in the decision that was given by the Supreme Court in the case. So one of the tests that was pointed out by the court is that the clause must be valid and clear. So it's not enough for the standard form contract to be referred to in the platform, but it must be clear, and the parties involved must clearly see it and also understand that the clause exists. Another test that the court applied is that there must be a strong reason to enforce it. And these two tests were picked from the case of ZI Pompey Industry versus ECU Line NV. So there are three major issues that was considered by the court as well to give their decision as seen in the case. One of the issue is that the contract was not negotiated. Therefore, it is unfair to say that that the user it is unfair to say that the user should be bound by such clause that he did not have the opportunity to negotiate. And that is actually one of the challenge of standard form contracts like click wrap agreements and browse wrap agreements, where users only just need to click I agree, and they are seen to be bound by such contract. Another issue is the privacy rights protected under the Privacy Act. The existence of a legal framework protecting the consumer's rights or the privacy right of such individual is what the court also considered, because there's an existence of a law which states that such users' privacy right has to be protected. Another issue considered was the protection of public interest as well. So the court considered the fact that taking the case to a different jurisdiction, irrespective of the forum selection clause as seen in the terms of use, will rather be unfair to the public. So those were the three major issues that the courts considered to give its decision in the case. So we look at some concerns also that have arisen from the case as well. So one of the concerns is the issue of enforceability of the forum selection clause. So the court rather saw it it has been difficult over time for the courts to decide which jurisdiction should have preference over the other for online transaction. But then over time, in a lot of cases, the courts have also been able to point out key factors affecting this enforceability. And one of the key factors affecting enforceability is a lack of mutual consent, because consumers do not have the ability to negotiate such standard form contracts. So it lack because of that, enforceability might be difficult. Then secondly, the issue of reasonableness. The forum must be connected to both parties. Where both parties are not in the same jurisdiction, say for example, the effect does not directly or indirectly impacts both parties, then enforceability is going to be difficult. However, it's not at all times that the forum selection clause is unenforceable. This was also decided by the court in the case of Carnival Cruise and Shoots, where it was held to be enforceable. Forum selection clause was held to be enforceable. And then the court stated that it can only be unenforceable if they are fundamentally seen to be unfair or they lack a rational basis. So if in contest, if it denies access to justice to consumers, then in such situation it will be unenforceable. Another factor affecting enforceability is also the issue of unconscionability. So where it is procedurally or substantively unconscionable because of the imbalance between the both parties, where the other person have little or no choice. If you do not want to access the service, you simply do not have to click agree to go ahead. So because of this imbalance, the unequal bargaining power, in some cases it might also be unenforceable. Another legal concern also arising from the case is the issue of judicial and policy consideration, jurisdiction and policy consideration, which jurisdiction should actually take precedence over the other, and also the issue of public policy. What does the public see it as? And if it is given, if the court gives room for the protection of the consumer's rights, would it affect the public? That's another legal concerns that have arisen in the case. And the last two concerns also that we saw in the course of our research is the power of imbalance in digital contracts. I think I've mentioned this before, the existence of the imbalance between the service providers or the platform owners and the consumers or people accessing the service or people entering into the online transaction, the lower party in this case. And then the last one is privacy rights consent. Uh, Critically, in the case of those against Facebook, it was seen and it was purely a case of privacy, a breach in privacy rights, because the lady did not give full consent to the use of her name and also profile on Facebook. So I think I've been able to touch major points of the case.
Very well, very well, very
Yeah.
well.
Thank you so much,
You
sir.
can see that that case and the others that you have discussed along the line have impacted what we will call our settled knowledge of the law in some subject areas. And I want to direct your mind to those subject areas. In the subject area of private international law itself, what we used to understand as the guiding principles in such cases as the eleftheria, we've gone through the elephteria, the Brandon test. I discussed it in my book. In such cases as the forum non-convenience issues and all of that, they would appear to be unsettled by these DAOs and Facebook case. That's one. Two, as lawyers, we have some working knowledge of standard form contracts. It will be good to look at whether the nature of internet transaction has warranted a need to amend the position of the law on standard form contracts. Okay? The rules as we knew them try to create a number of grounds for the parties who did not bargain at arm's length. Okay? Who is the weaker party, and that to take the contract or leave it. But we know the grounds, the settled grounds upon which the court will bypass the standard form. Okay? Can we compare those settled grounds with the decision in DAOs and Facebook? DAOs and Facebook does not complete the story. Reason is that we will still have to examine on the basis of the principle of committee, what is the effect of that decision? Suppose the other party does not have asset in the district where the action was instituted. Do you think that the district where the other party has asset, or the district where the other party has principal place of business, would easily accept enforceability of the judgment that will be given by the British Columbian district? In that instance, we have not done enforcement of foreign judgment, but one of the grounds of enforcement of foreign judgment is that the court that determined the matter must have been seized of jurisdiction in the international sense. Okay? And we have seen cases where at the point of enforcement of judgment, that question is asked again. And the answer, which was given by the court that gave the judgment, is not necessarily sufficient. Because the court where you are seeking to enforce the judgment will have a own conditionality for recognizing the judgment you have obtained. And we have seen cases at common law where the English court had said that the basis of the exercise of jurisdiction was exorbitant. And on that basis, the judgment was not going to be recognized or enforceable in England. We have seen cases even where judgment debtors have been dragged, so to say, into the territory of the court that gave the judgment. And most registration regime now would tell you that those conditions are absolutely important for the judgment to be enforceable. Namely, that either that the defendant resides in the place where you have sued him, or voluntarily submitted to the jurisdiction of that place, vide many things, including pre-agreement. That is an agreement that is the place where you are going to litigate. In the particular case of Dawes and Facebook, we do not know the details now, but it is most likely that or if the situation were to be that Facebook had no principal place of business in British Columbia, and the standard form, which in this case is represented by the click the button to accept, indicates that the other place, is it California or whatever you call it, that will entertain the matter. You will then find that the requirement to register that Canadian judgment in California or wherever the standard format insisted that action should be instituted, was not going to satisfy the registration requirements of California or whichever is the legal district that Facebook indicated it should be sued. So there will be issues of enforcement of judgments. There will be practical issues for you to take as the counsel to do it in that type of case, because you not only want an award of a sum of money to you, you want to get to realize the fruit of the judgment by being able to enforce it. And so these are issues that you would have to examine. We'll see what that case decided now. It has impacted on standard form. It has probably applied the rules of standard form or even done a progressive development of them as it relates to internet transactions. But will every country where the judgment debtor has assets accept the judgment that would have been delivered by the British Columbian courts under this circumstance? So these are the issues. These are the issues that you should look at. Okay? So if I ask you a question, take down this. In the light of the decision, of the Canadian Supreme Court in the case of Dwes and Facebook, cite the case properly. I don't have any material with me now, so I can't remember the full citation of the case. Cite the case properly. In the case of decision of the Canadian Supreme Court, in the case of Dwes and Facebook, okay, discuss how internet transactions have impacted otherwise settled rules, in the following subject areas. One, Roman figure 1. Exclusive foreign jurisdiction clauses. 2, standard form agreements. Standard form agreements. And 3, the requirement of jurisdiction. The requirement of jurisdiction as a condition. The requirement of jurisdiction as a condition for the recognition and enforcement. For the recognition and enforcement of a foreign judgment. Okay? Go through this presentation and see how it helps you to answer this question. Okay? So let's talk briefly on enforcement of foreign judgments. So that we don't have to come next week. Can we go on?
Yes, sir.
Yes, sir.
Okay. So when we are talking about the enforcement of foreign judgment, what we are saying is that, just like the last presenter has said, the Supreme Court of Canada said British Columbia should entertain the matter. Is that not so? British Columbia will entertain that case now and will end up most likely giving a judgment that will be against Facebook. Okay? If Facebook does not have any asset, whether money in bank or other movables or landed property in British Columbia, it will mean that US would have to go to wherever Facebook has those assets to enforce the judgment that British Columbia will give. So what we are now talking about is which rules will determine enforceability, just like the whole gamut of private international law. The rules that will determine enforceability will be the rules of the legal district that US will go to. It won't be the rules of British Columbia. So that's what we call committee principle. When you are coming up with a judgment like US, okay, there's a need for you to consider what will be acceptable to the whole world, especially if your judgment will have to be marketed elsewhere. Because if the court of other countries will not recognize your judgment, then you have acted in vain. So in this example now, whatever British Columbia courts will give as judgment, unless Facebook has assets in British Columbia, the judgment will have to be taken elsewhere. And the country in which Facebook has assets would have to be required to recognize that judgment. If it doesn't recognize the judgment, it will not be able to enforce them. So the first thing you need to know is what is the distinction between recognition and enforcement. and I think we discussed it earlier, that because the judgment of the court of one country is part of our own sovereign acts, and because sovereign acts have territorial limits, the judgment given by the Nigerian Supreme Court, the territorial limit of its effectiveness is Nigeria. Unless the Republic recognizes that judgment, you won't be able to enforce that judgment at Ajase. So Benin Republic legal system will have to first recognize it. Okay? So it is often said that recognition is a requirement for enforcement, but not all recognized judgment will need to be enforced. Please take down that statement. It may be a question in the exam. Okay? Recognition is a requirement for enforcement, but not all recognized judgments need to be enforced. So if a country's legal system does not recognize the judgment, you can't even be talking about enforcing the judgment in their territory. That was the question I was raising with that noise. That whereas the Canadian Supreme Court seemed to have given the British Columbian courts the go-ahead to entertain the matter, the other question to be answered is, suppose Facebook does not have access to British Columbia, and whatever is awarded as damages will then have to be recovered elsewhere. How acceptable would the basis of British Columbia assumption of jurisdiction in the matter be to other countries? If it is not acceptable to other countries, then all of the effort have been in vain. That's what we are trying to say. So what are the requirements for recognition of foreign judgments? Whether at common law or under a registration regime, they are almost all the same. Number one requirement is jurisdiction. Jurisdiction. You see, courts of different legal districts will have their own different rules of jurisdiction. But when judgment is obtained in one legal district and sought to be enforced in another, it is not the rule of jurisdiction of the court that gave the judgment that will matter. It is the rule of jurisdiction of the court where the judgment is sought to be enforced that will be absolutely important. So, at common law, and in most countries' legislation regime, it will be required that the court had assumed jurisdiction on certain basis. One of them is that the judgment debtor must either have been resident in that country or must have had a principal place of business there. Okay? Either is resident there or has a principal place of business there. Okay? Or voluntarily submitted to the jurisdiction of the court. What do we mean by voluntary submission? The judgment debtor had the option not to answer because maybe he's being sued in the wrong place. Like Facebook was complaining that it was being sued in British Columbia, whereas it should have been sued in the California legal district in America, if I get the facts correctly. So, but nevertheless, it entered unconditional appearance. Now, there is no difference between entering conditional appearance and not entering at all. So in that 1000 Facebook case, another battle would await those if British Columbia gave judgment eventually against Facebook, because Facebook would naturally say that British Columbia had entertained the matter without jurisdiction. And it did not matter that the Canadian Supreme Court said it has jurisdiction. No, because the basis of jurisdiction in that sense will be the basis known to the legal district where the judgment is sought to be enforced. And so most legal districts will say, if the man does not reside in your country, he doesn't have a principal place of business there, he must have voluntarily submitted. And voluntary submission has a lot of meaning. One of them is a pre-agreement that this is the place we will litigate. Okay? You could see that in that case, the pre-agreement, whether you like it or not, was not British Columbia. The exclusive foreign jurisdiction clause was another district, another legal district. So that is the first requirement. Second requirement is fair hearing. Opportunity must have been given to the judgment debtor. Okay? In other words, it must have been served. Okay? Third one, fraud. There must be no fraud. Okay? Fourth one, the judgment must be a final judgment. You don't go on enforcing interlocutory or interim orders. Okay? Fifth one, public policy of the forum. That is public policy of the forum of enforcement. If you are seeking to enforce a foreign judgment in Nigeria, and the substance of the judgment is one that runs contrary to our public policy, our court will say that if you had brought this case to Nigeria, we would not have entertained it because what you are seeking for runs contrary to our public policy. It does not make any difference that you have gone to a country where their own law, where their own policy does not forbid them from giving the judgment. What we will do here is refuse due enforcement. That's contrary to public policy. Okay? So all these are conditions for recognition. Okay? Like I have said, you cannot enforce a judgment that your legal system does not permit you to recognize. But the mere fact that you have recognized the judgment itself is not the end in determining enforcement. There are additional requirements. The additional requirement is that the judgment must be a judgment for payment of money. It must be a judgment for payment of money. The sum payable must be fixed, or there will be a formula for determining what it amounts to. And the sum payable must not be a tax. Okay? So what is the difference between recognition and enforcement? You will find that some judgments by their very nature only relate to status. For example, if a judgment dissolves a marriage, that is a status judgment. If it merely dissolves the marriage without making any orders to alimony, that is a payment of money by one spouse to another, then the judgment relates only to status. if Nigeria recognizes that judgment, you will see the impact in a situation where one of the spouse of that marriage is seeking to remarry in Nigeria. The other spouse will not be able to raise a caveat or objection against the marriage because the registrar will tell him that, well, there's a divorce obtained from country X, and we accept that divorce. And we know that the implication of that divorce is to set this person free to remarry. So your objection is rejected. So that means you have recognized the judgment. It doesn't mean that we have enforced the judgment because we are not going to execute any particular order. We are only going to recognize the order in approving steps to be taken in Nigeria. So when a judgment relates merely to status and does not go ahead to order the payment of money, what you need is mere recognition, not enforcement. But if the judgment not only relates to status, but also order the payment of money, then it will need enforcement. And so you would have to look at our own rules. If in Nigeria is the place where you want to enforce the judgment, you have to look at our own rules for recognition and enforcement, which I have given to you at common law. Okay? Now, what is the mode? If you want to enforce a foreign judgment in Nigeria, there are two modes. The first one is the common law method. The common law method will permit you to sue upon the judgment. To sue upon the judgment. That is, you don't want to revisit the facts. You just present to the Nigerian court that so judgment was given in so case. Okay? And the foreign court awarded this. You want the Nigerian court to award the same thing that the foreign court awarded. That's what we mean by suing upon the judgment. There's a difference between suing upon the judgment and suing upon the course of action. To sue upon the course of action is to ignore the judgment and represent the facts afresh. Okay, the common law method will not permit you to do that. What the common law method will permit you to do is to present the reliefs in the judgment as the same reliefs that you want the court to adopt, so that you will now have a Nigerian judgment upon the same reliefs. That is what we mean by suing upon the judgment. So that's the first method. And so everything we have said about the requirement for recognition and enforcement applies to this one. No statute regulates it. The period of limitation depends on where you are going. Some states in Nigeria give you 12 years. Others give you 10 years as time limit to enforce judgment. It is the same as local judgment. We as lawyers, you know, if you obtain a judgment there, you have either 12 or 10 years within to enforce it, depending on what state. You go to a state like Rivers, the limitation period for enforcing it is 10 years. If you come to Lagos, the limitation period is 12 years. So that is the way it is when you are coming at common law. But we now have a second method, which we call the registration regime. The registration regime just permits you to obtain CTC of the judgment and get it registered. in the courts in Nigeria in whose territory the assets of the judgment debtor is. That one is regulated by statute, and there are two statutes. The first one is known as Enforcement of Judgment Ordinance of 1922. It was last listed in the laws of the Federation of Nigeria as Chapter 175, Laws of the Federation of Nigeria, 1958 rather. Cap 175, LFN 1958. The other one is known as Cap F35, Laws of the Federation of Nigeria, 2004. It is called Foreign Judgment Reciprocal Enforcement Act. Okay? So that is the legislation regime. The difference between the common law regime and the legislation regime is that in the common law regime, you sue upon the judgment. In the legislation regime, you register the judgment. You obtain a certificate of the judgment from where it was given and register it. But what are the requirements under statute as compared to the requirement of common law? They are virtually the same. You find that those requirements for the requirement of jurisdiction is well codified in the relevant sections of the two statutes. Okay? The other issues are technical issues, and you can read any text on enforcement of foreign judgment in Nigeria if you have. If you do not have, I have an article titled, put down the name of the article, Commonwealth Model and Conundrum in the enforcement of foreign judgment regime in Nigeria. Commonwealth Model and Conundrum in the enforcement of foreign judgment regime in Nigeria, end of quote. I'm just mentioning that to you because that's the one I can remember. Many other people have done something on enforcement of foreign judgment, especially as regard the mood, as regard issues arising from the provisions of the two statutes. I will be fair to you. What I have not given, I will not ask. Just concentrate on, so far, what I have said. Which rules will govern recognition and enforcement? Is it that of the court where the judgment was obtained, or that of the forum where you want to enforce it? Two, what is the distinction between recognition and enforcement? And why do we say that recognition is a precondition to enforcement, but not all recognized judgment need enforcement? Three, what are the basic differences between the common law regime and the legislation regime? I've already given you one, which is that in the common law regime, you sue upon the judgment. In the legislation regime, you register the judgment. The other one is the time limit. The common law regime, you have the same time as the time you have to enforce judgment obtained in Nigeria, which, depending on the state where you're enforcing it, is either 10 or 12 years. But the legislation regime prescribe different years, different time. For example, Chapter 175 LFN 1958 prescribes 12 months. You must come to register the judgment within 12 months unless the court grants you leave to extend the time within which you may register it. Whereas the other one, CAP F35, LFN 2004, prescribes 6 years. Okay? So, there are other differences, but if I want to go into that, we will not finish today's lecture at 9 o'clock. Okay? So I think I've given you enough hint. Already, you have like 2 questions in your kitty. The question I set, when group one I set, when group 2 presented, something along those lines would come out. Then just revise every of the things we have, the basic questions, and you have seen how much I've spoken about enforcement of foreign judgment. I have not done 1/4 of what enforcement of foreign judgment is all about. But it is within that 1/4 that I will examine you. So if you are listening to this lecture, you already have 3 questions in your kitty. I will think out the 3 other questions. And you'll be home and dry. They will be simple things that we discuss in class. So I wish you best of luck in your exam. When are you writing the exam?
Is in September, sir. I think on
September.
the 2nd or 3rd of September.
Okay, so go and read. Today alone, you have gotten 3 good hints regarding questions
Hello,
that
sir.
will come. Yes.
Sir, I have one question, sir.
What is the
On
question?
the enforcement of foreign judgment. I want to assume there is like this case of Drex and Facebook. Assuming now the Drex has gotten the judgment from BC, from British Columbia, but if the Facebook does not reside or having the principal business in British Columbia, and he does not have asset in British Columbia, but the US discover the asset of the Facebook in another jurisdiction.
Yes, you can go there. You can go to any jurisdiction where Facebook has assets. But what will determine recognition and enforcement will be the rules of recognition and enforcement of that jurisdiction. If, for example, US comes to Nigeria now, to recognize and enforce the judgment, we will be applying our own rules of recognition and enforcement, not that of British Columbia. That's what I was saying about discussing how that judgment would impact enforcement of foreign judgment, especially if assets are located elsewhere. Do you understand?
Thanks, sir. Yes, sir. Yes, sir. Thanks, sir.
Okay, sir, good evening, sir.
Good evening.
This is Tim Jacques, sir. Sir, please, I have something to say, sir.
What is the thing you want to say?
Okay, sir, it's regarding the other 3 people. Sir, actually, as of yesterday, we were hoping that we were going to give the 6 people that were not listed for CA a new topic, or you will give a mandate that they should join the other 2 groups until I passed your message across to the group yesterday evening. So, sir, I would like to plead on behalf of the other 3 people to also be reconsidered. Either they should join group 1 or group 2, sir. Because they were all open to be given a new topic to work on together or to be mandated to join the other 2.
There are 2, you treat like cases alike. The first 3 people, the people in group 1 said, they actually joined us. So they were hoping that you would approve their inclusion in group 1. But the 3 people you are talking about now, they didn't join in doing group 2 work. So how can we just allocate to them whatever mark we give to group 2? That's not fair to those who did the work in group 2. It's not a question of asking them whether they agree or not, but it will not be fair to them. So they have nothing to lose. Let them do well in the exam. We have the rule that we normally apply in this type of situation. They may even do better than those who participated in any group work. I can decide to say, okay, since I've marked every script over 80, these 3 people who, for no fault of their own, did not have any group, I want to decide that I will give them the score they have in their best question. Something like that. For example, if they now did their 4 questions, and it was in question 2 that they had their best answer, and that fetches them 13/20 or 12/20. We just repeat that 12/20 for CA in recognition of the fact that we have no basis of assessing them for CA. They may even be luckier. It may well be that those of you who have taken all of the pain to write the seminar paper didn't score more than that same 12 or 13/20 in the CA. So they have not lost anything. Okay? But justice must not only be done, but it must be seen to be done. How can we just allocate them the mark of a particular group when they did not participate? I don't think it will affect them significantly. They should just know now that there is no largesse for them. But if they do well in 4 questions, they might as well even do better than those who were assessing on the basis of CA. So they have not lost anything. They have not lost anything, but they should know now that if your name is not in a group, we can't give you the mark of the group. Okay? The first 3 people, their case was different because they had actually participated according to group A people themselves in the write-up. Okay? Before I retrospectively approve them to be there. Do you understand? Hello?
Yes, sir. Yes, sir.
They have nothing to lose. And if it turns out that I also ask a question regarding representing what they said, one thing is sure, if I ask the 2 questions I suggested to you people today, I won't ask the question about presenting what you said in the seminar again, because it will be that I'm not examining any other thing than what you presented today. So it's either I ask that one or I ask present what you said in your seminar paper and I make it compulsory. So if I say present what you said in your seminar paper and I make it compulsory, I'm telling them in order for them not to lose 20 marks, they should just introduce their situation and say they have adopted the presentation of any of the 2 groups. Again, that's an advantage for them. It's an advantage for them. If your name appears in group 1, you cannot be telling me that you did group 2. You cannot be telling me that you did group 2. Okay, come. You can't be telling me that you did group 2. But if your name is not on any of them, and haven't studied the 2 of them, you think you can present group 2 better, you can say that that's what you adopted. I don't think they have anything to lose. They don't have anything to lose, really. It's only that in justice, we cannot allocate the mark of any group to them when they are not seen to have participated. Is it clear?
Yes, thank you, Prof. Good evening, Prof.
Yeah, good evening.
Yes, Prof, I have a question concerning your explanation as to the approach or the mode of suing for the enforcement of judgment under common law and under the Act. The first one is where the judgment in question is not a judgment sum, but relates to
It's not.
property from a
It's not what?
matrimonial cause. Would that come up? It's not a judgment sum. It's not a sum of a certain sum of money,
I don't.
but relates to property.
It's not a judgment at all, or what did you say?
No, it's a judgment, but it's not about a judge. It's not a sum. It's not in respect of a sum of a certain amount of money ascertained in that judgment.
Yes. It's a status judgment.
But it relates to a property arising from a matrimonial cause. For instance,
Okay, matrimonial property.
Matrimonial property, yes. Yes, sir.
Well, when you say sum of money, money includes something that you can put in monetary form. If, for example, the judgment says they were living in Ikoyi and that the wife should remain in the Ikoyi home, okay? That
Yes,
is an
sir.
enforceable judgment. That clearly is an enforceable judgment. So
Okay,
not
now,
only will the Nigerian court recognize the decree of dissolution, the Nigerian court will go ahead to give effect to the order as it relates to matrimonial home. Even though there will be other issues as to question of jurisdiction, whether in the light of the matrimonial home claim, the Ghanaian court was even right to entertain the matter, the foreign court was even right to entertain the matter in the first instance. Do you understand?
yes,
If, for
Prof.
example, State X has entertained a matrimonial dispute between A and B, and the key relief there, apart from ordering a dissolution of the marriage, was allocating the matrimonial home in Ikoyi to either spouse. Okay?
Yes, Prof.
If you want to enforce that judgment in Nigeria, the first challenge you will face is whether the court that entertained the matter really had jurisdiction.
Okay,
In
Prof.
the international sense. Do you understand?
Yes,
Because
Prof.
under our own law, once you are seeking relief relating to possession, you go to the where the property is. That is the rule in British South Africa, compare the Mozambique. So the problem with that will be if you are enforcing in Nigeria or in any common law country, there will be the challenge of why did you go to the country where the so-called matrimonial home property is not located in the first instance? I hope you understand what I'm saying.
Yes, Prof, I understand that. But then the next follow-up question to the explanation you just gave is in a situation where the court went, the foreign court judgment went ahead to spell out what the nature of property and how it should be distributed. And the property in question is a real property. It has to do with the building. So for instance, the court said, look, your building number 24.
Sir, once it has to do with real property, not choices in possession.
Yes, Prof.
The rule in BSC and Compare de Mozambique will apply. The rule in BSC and Compare de Mozambique will apply if you are seeking declaration of title, if you are seeking possession, and if you are seeking damages in respect of any tort to landed property. And the rule is that you must go to where the property is. Okay? So that's the common law basis of jurisdiction. And so if the court had assumed jurisdiction on any other basis than that, when you want to enforce it here in Nigeria, we will be interrogating whether the court had jurisdiction in the first instance, which is the first requirement for recognition.
Yes, Prof. That's cleared up, Prof. Thank you so much, sir. Then the second
Yeah.
question is, in an application to the court for recognition, how are we supposed to come? Is it by way of ex parte or by motion on notice? I don't just understand that area.
To the court
The procedure
for enforcement,
recognition, for recognition and enforcement. Yes, Prof.
Yes. The statutes prescribe what you should do. The Cap 175 does not say any method you can use, but the rules made pursuant to it say you should file a petition. The F-35 talks about, that is the 2004, talks about application for registration, application for registration. It doesn't say petition, it says application. But if it is common law, you don't have any problem with common law method. All you need to do is file your normal writ, and in your statement of claim, you plead the judgment. You plead the judgment, okay? And in your relief, you adopt the same relief that the judgment had given. Chikena, it's like a debt recovery.
So but then there will be a requirement service of that originating process, Prof, on the judgment debtor.
That is the reason why you are coming to Nigeria now, because you think the man has assets in Nigeria and is present in Nigeria. So, of course, you have to serve. The only one where you might proceed ex parte is the F-35. And the reason is that in the F-35 case, it is after you have registered the judgment that the other party will be given the opportunity to come and set it aside. Do you understand?
Yes,
At the point you are applying to register the judgment, is an administrative process. It's just like the ex parte application you bring when you want to serve notice of writ abroad. But
yes,
the opportunity will then be given to the judgment debtor. Okay? After the judgment has been registered, for him to come and set it aside. But Cap 175 regime is different. It expects you to put the other party on notice even before the judgment is registered. There are two different regimes. The Cap 175 one expects you to put the other party on notice and for argument to be listened to before the judgment is registered. The F-35 regime would take your application ex parte, but will now mandate that you notify the other party after the order has been given, and the other party will then apply to set it aside. So they target the same end, but the procedure is different for both statutory regime. But the common law regime is the straightforward one. You are suing the same way you take action. That's the way you take. The only thing is that instead of you traveling through the route of stating all the facts preceding your obtaining the judgment, you will just briefly introduce that you obtain so judgment in so country, and these are the reliefs the court has granted, and that you want the Nigerian court to grant you the same relief that the court has granted. That's what we mean by suing upon the judgment.
Okay, thank you so much, Prof. Then the third, perhaps the last question is, in the example we've been using, that's the matrimonial cause, let's say it's a divorce matter. What court would we be approaching in Nigeria? Is it the court that has jurisdiction over matrimonial causes, like the High Court of the state, or any court, including the Federal High Court?
That one is a straightforward matter. If you want to enforce a judgment, it's an interesting question, really. If you want to enforce a judgment, the way to see it is that, and this might be my own opinion, because there's a decision contrary to it. The way to see it is that enforcement of judgment itself is a course of action. Enforcement of judgment itself is a course of action. And the relevant statutes, and by implication, the common law, says that you will enforce judgment in the high courts. And the high court is defined to be either the state high court or the federal high court. So you won't be permitted to go to a magistrate court, for example. Okay? But you can go to either federal high court or state high court. But there's a particular case. Which involve this former MD of Intercontinental Bank. What's his name?
Erastus
Akingbola.
Akingbola.
Erastus Akingbola and Access Bank. Erastus Akingbola judgment was obtained against him in the UK. Okay? When Access Bank sought to enforce the judgment, the first applied to the High Court of Lagos State. And the rest of the Akingbolah's lawyers objected to the jurisdiction of the Lagos State High Court. Because of what? Because according to them, the original cause of action was company law. And only the Federal High Court had jurisdiction to entertain company law. So instead of coming to State High Court, they ought to have gone to Federal High Court. I look at it and say, what type of stupid submission is that? I'm sorry, very senior lawyers put it up, but I thought as a conflict of law person that it was a stupid submission. I'm sorry, use the word stupid and quote and unquote. The reason is that you look at the statute says you can go to the High Court, and that court for this purpose means Federal High Court or State High Court. Is that not the same thing that we encounter in the enforcement of fundamental human rights? Today, if you want to enforce any issue, you want to enforce anybody's fundamental human rights, the discretion is yours, absolutely, whether to go to a state or a federal high court. Nobody will say, because the agency against whom you are enforcing right are state courts, you should have gone to state high court. Or because the subject matter was originally a federal subject matter, you should have gone to federal high court. I don't think anybody will raise that argument because the relevant Supreme Court rules on the matter had already said that you can go to either a state high court or a federal high court. So I thought that question was unnecessary. But the other reason why I thought the question was, it betrays lack of understanding of the subject, is that when you are enforcing a foreign judgment, you are suing upon the judgment. You are not suing upon the course of action. So nobody is looking at what is the original reason why you went to UK court. Nobody wants to examine whether Nigerian company law has been properly applied or not. So the expertise of a federal high court was not necessary. A foreign judgment is a debt. And so to begin to argue that which high court do you go to, is to me, it betrays lack of understanding of the subject. Okay? So to answer your question specifically, if a judgment was given in a matrimonial cause, which also carries an order for payment of money, the type of order that you need to specifically enforce, then you are permitted by our own enforcement of judgment law rules to go to High Court. And High Court is defined as High Court of the state or High Court of the federal. So both of them will have jurisdiction in the matter. But you know that commonsensically, it is the state you will go to. The reason why you are going to the state is not because the state is the only one that has jurisdiction to entertain matrimonial causes, because you are not suing upon the course of action. So
Prof,
if
as a,
somebody
as a
has to go
follow-up,
to a federal high court, I don't expect the argument to succeed that because matrimonial causes is a state matter, it are going to state that court. No. Enforcement of foreign judgment itself is a course of action. And the relevant statute that permits it says you can go to a high court. And that court for that purpose is either state high court or federal high court. Is it clear?
yes, Prof, thank you very much. That's very clear. But I just thought of something, just my thoughts, and I thought I should share with the class and perhaps hear what others might think about it. So in a situation where the question of registration borders around whether the court that gave the foreign judgment has jurisdiction in the first place, is it not advisable to think that the court that has jurisdiction over the subject matter will be better off prepared or equipped to determine the question of whether the foreign judgment or foreign court has jurisdiction to entertain the matter in the first place? Given the subject matter.
Give me the reason why you are saying so. Because if you are seeking to register the judgment, you are going to rely on statute. And the statute has prescribed the conditionalities.
Okay, now
none of the conditionalities go back to the original cause of action. The conditionality did not say they should reject the judgment if the foreign court has misunderstood Nigerian company law.
No, the question has to do with now, if in determining the criteria or the conditions for registration according to Nigerian law, the question then arises as to whether the foreign court itself has jurisdiction to entertain that subject matter in the first place.
Yes, and I'm telling you that the condition for the court to have jurisdiction is a matter of statutory provision, black and white. It's there in the statute. It doesn't require you to revisit the original cause of action. The issues relating to jurisdiction in those type of instances are largely territorial. They largely have something to do with the connection of the judgment debtor with the place where the action was taken. Like, was he resident there? Did he have a principal place of business there? Did he voluntarily submit? And voluntary submission has several meanings, including pre-agreeing that that is the place where the case will go on, okay?
Yes,
including after he was served, he entered some conditional appearance. Which of these would have required the special expertise of a company, of a court that was established to entertain company law matter in Nigeria? That somebody will now say, go to the court that was established to establish company law. What has company law got to do with the issue? We are not going back to the course of action, for God's sake. If we were going back to the course of action, then you could argue that, well, there is a court that knows company law in Nigeria. They will be able to say whether Nigerian law was properly applied or not. That's not the question in the enforcement of foreign judgment. You don't go into the merit. You are not revisiting the merit. You are just enforcing the judgment. You are just registering the judgment and giving effect to it. If anybody wants to revisit the merit, the person should go to appeal in the country where the judgment was obtained.
Yes,
so
Prof,
to me, it's an elementary betrayal of knowledge of the subject area.
Yes, Prof, I seek really quick. I really seek clarification in this area because I'm a little bit confused and I'm trying to find my footing here in understanding the concept. Maybe my explanation is a bit unclear. What I'm trying to bring out from this is this. We use the example of the Duels and Facebook Incorporated case, where the question of enforcement, you explain that if Facebook has no business place in Canada and eventually God's judgment was given against Facebook, and now there's need for that judgment to be enforced, Now, they need to enforce this judgment in any jurisdiction where they can find Facebook's assets. Now, the question then in that court will be, like you said, one of the conditions for enforcement is whether that court that gave that judgment, that foreign judgment that is sought to be enforced now, has jurisdiction in the first place to determine that judgment, to determine that dispute, to entertain and determine that dispute. Now, assuming now, this example now relates to a matrimonial cause or something else, maybe antitrust or company proceedings. The question there is, will it not be better that the court that has jurisdiction to determine whether it has a matter falls within its jurisdiction is approached so that that court will better determine the question of whether the other court too, the foreign court, had jurisdiction in the first place to entertain and determine the matter?
And I'm giving you the same answer that your question does not show understanding of the subject, sir. In private international law, our issues are territorial and nothing more. Let me give the Facebook example that you have given now. Suppose judgment was given by the Court of British Columbia against Facebook, and suppose the head has come to Nigeria, okay, has come to Nigeria to enforce that judgment, maybe because Facebook has asset in Nigeria, okay, and suppose the subject matter of the dispute, if it had been a case instituted in Nigeria, would have gone to the Federal High Court and not Lagos State High Court. Okay? For the judgment debtor to be raising objection to the jurisdiction of the Lagos State High Court is for it, if it is raising objection on the basis that Federal High Court is the one that knows Nigerian company law and will be able to decide the matter, then it means that the judgment debtor is operating on the basis that the issue before the court is the original court of action. The issue before the court is enforceability of the British Columbia judgment. So if you apply under any of the statutes have prescribed, first of all, the same statute has said you can go to any of the two high courts. That's all it said. It didn't say any more. And the issue before the court is the judgment enforceable or not? The law that the court would examine to determine whether the judgment is enforceable or not are in the very statute. They don't require specific understanding of the course of action. So on what basis are you saying that the man must go? Look, it's a pity we cut short the lecture. Go and read the theoretical basis for enforcement of foreign judgment, especially the doctrine of obligation. Why do we enforce foreign judgment? We do not enforce foreign judgment because we like them or because they apply our law or any law very well. Question of law is not necessary. We enforce them because we have seen the judgment debtor as being under an obligation to abide by the judgment. Why will we see him as being under an obligation to abide by the judgment? We will see him as being under an obligation to abide by the judgment if he has any connection that we accept, the connection that we accept with the country where the judgment was obtained. Which of these is subject matter? Which of these has something to do with company law or with matrimonial causes or with whatever that you will say in Nigeria, state high court, they don't entertain company. This one, it's a clear display of ignorance of what the issue is about. Enforcement of foreign judgment is a cause of action on its own. And the statute that permits it has said go to federal high court and state high court. And not only has it said so, it has given, there is no even, in fact, if you can read and write, you don't even need to be a judge. You don't even need to be a lawyer. If you can read and write and you have the statute before you, all the argument can begin and end with the statute. Nobody will come and raise what does Section 399 of CAMA say about minority rights. That's not what they are disputing. And if the reason why you need to go to the federal high court, if that were your cause of action, is because the federal high court is the special court for the matter. That does not arisen in this case. What has arisen in this case, very simply, is that a judgment has been obtained in Canada. Okay?
Yes,
Given the connection of the judgment debtor with Canada, is it a judgment that our own rules of enforcement will permit us to enforce? Now you tell me which of the high courts can claim to be specialized, more specialized than the other in that one? It's an unnecessary question. The problem with us is that once our senior advocates raise issues and the judges don't have answer, they just succumb to them. If you were raised that type of issue before me as a judge, I will tell you, you don't know what you are saying. I'll tell you, you don't know what you are saying. That I don't have jurisdiction because I'm not a court established to treat company law. And I will ask you, is this a company law matter? It is not a company law matter. So in the same way, if we are relating it to the Downs case, the issue is Facebook sufficiently connected with British Columbia in the light of the facts so that we will say that British Columbia had jurisdiction against it. That is not a marriage issue. It is not a tort issue. It is not a company law issue. If you want to regard it as an issue, it is an enforcement of foreign judgment issue. So nobody is a specialist, no court, none of the two high court is a specialist in it. As for one to say, you should take it to this one. I think it's a clear misunderstanding of the subject. It remains my view. It remains my view, but yes.
Sir, I just thought to say something because I've been listening to my colleague's question, and it was a misunderstanding I also had when I started this course. I think the foundational issue is we thinking that the definition of jurisdiction in the normal parlance, in the normal legal parlance, is the same thing in private international law. So I guess that's the foundation.
Professor Akpete used to explain it to us in our days in the LLM class. He will qualify jurisdiction. He will use quote and unquote international sense. So the requirement of jurisdiction is jurisdiction in the international sense. That's neither company law, nor marriage, nor tort, nor anything. It is territorial. We are examining the connection of the judgment debtor with the country where the judgment was obtained. If it was dragged there, then the court didn't have jurisdiction. Okay, I'll give you a case. If you this is a case of Gazan Alohi, Gosmos Casinos and Gazan Alohi. Go and read that case. Okay, the Supreme Court of Nigeria eventually ordered that a judgment of UK court was unenforceable because the Nigerian judgment debtor was dragged to UK court virtually because he neither lives there nor has any principal place of business there. But I think he was served by way of assumed jurisdiction. Leave was obtained to serve him here in Nigeria. And I think, having failed to appear, the UK court had gone ahead to give judgment Okay. The lower court then said, when he now challenge the registrability of the judgment on the basis of jurisdiction, the lower court then said that for it to question, to enter that case, to entertain that question will be as if it is sitting on appeal over the UK court that had given a ruling on the matter. Okay? But the appellate court overruled the lower court. Say, what are you talking about? If you have no power to look at this issue, the statute would not have said so. The statute said, before you register the judgment, you should be sure that the English court had jurisdiction. And he went ahead to spell what jurisdiction means in the context. Either this one resides there, or this one has a principal place of business there, or this one voluntarily submitted there. Which of them have been met? If they now say their own equivalent of our own order 10 rule 1 was applied to give notice to Aloy in Nigeria, Aloy haven't refused to come, they went ahead. Which, does that meet the requirement of our statute? It doesn't. So the Supreme Court set aside the judgment. Eventually, even the what is his name? The Access Bank case too ended on that note too. Now the man doesn't live in UK. The UK court didn't assume jurisdiction over him in the international sense as prescribed by our statute. So tell me, what is it that the Federal High Court has special skill in answering on that one that the State High Court does not have? When all you need to do is, so the basic thing is that you are not revisiting the course of action. And our own rules, our own local rules on subject matter jurisdiction are not relevant. Even if you want to look at a legal district rule on subject matter jurisdiction, it's not going to be Nigeria's own. You are going to look at UK's own. Assuming the UK law has said that that type of matter should go to court X, but the matter went to court Z, then you have a grant. The court of the foreign forum had no internal competence. That's a good reason. Which is different from all the issues you are raising.
Yes, Prof. Thank you very much, Prof. I think I have a better understanding.
Prof, sir,
yes, Prof.
I think
Thank
from
you.
your explanation now, the argument of Leonard's sake in that Akigbola is like revisiting or rehearing the case that international court has.
Yes, and that was not the issue before any Nigerian court.
That was not
That's
the point.
not
That
the
is
issue
what they
before
will
any
be guilty.
Nigerian court. The issue before the Nigerian court is a judgment that has been obtained by so court in England. Given the fact of the relationship of what's his name with England, as at the time the action was instituted, is it a judgment we should recognize or enforce? That's the question.
You really appreciate, sir.
Yes.
I just get the gist.
Thank you so much, Prof.
Prof, we really appreciate, sir.
Okay. So see you on exam day. Please pass the exam.
All right, sir.
Nobody is interested in anybody failing.
Thanks, sir. Really appreciate, sir.
Yeah.
Good night, sir.
Yeah, good night.
Interesting case.
Thank you, sir.
Good night, sir.
Right.